Mr. Palmer, do you wish to give a closing argument?
As it turns out, I do.
You may.
Thank you, Judge. Michael Keller is not a criminal. Michael Keller did not commit a criminal act. The prosecutor spent 54, I think, minutes here, a little less than that, arguing about how these instructions prove to you, when you compare them with the evidence, this man has committed a battery. Let's focus on a few of the other things that he said. He didn't charge him, and he admonishes you folks, leave outside the jury room door any of your personal opinion of anybody that may have attended the event, people who may have been hosting the event, the way you may view the viewpoints of their Michael or his accuser or their witnesses, and that under no circumstances, because we are a nation of laws, would he have let, or the detective have let, their personal opinion, their politics come into their charging decision. Okay, let's work with that. Let's say that's absolutely what happened, just for the sake of discussion. Now, how do we know that Michael could not, under the facts that have been presented, if we're leaving all of that outside, all of that at the door, have committed a criminal act here? Based upon the evidence which they gave, and certainly you can look at the evidence that we gave. Here's how we know he couldn't have committed a battery under the facts, because he planted himself in an aisle where he has a right to be. His accuser came up behind him where he can't see her, and has admittedly, and is on video, putting her hand on his arm and attempting to push herself through the space that he's occupying. But that, apparently, even though it's admitted to, even though it's on video, is not, according to the state, a battery. Defined. Instruction 13. Willfully and unlawfully uses force or violence on the person of another. That's choice 1. Actually, intentionally, and unlawfully touches or strikes. It doesn't require the strike. A bite, kick, punch, push. Retired career requires a touch. It's intentional. It's unwanted. So, not incidental jostle. It's not being packed into the crowded elevator on shoulders or elbows or something rubbed with the other person because everybody's stuffed in there like sardines. It's an intentional act to have contact with a specific other person. She intended to have contact with him. You've got it both by her admission and on video. But that apparently is okay. All right, just a light tap is what we're told the counsel, his accuser, just to acknowledge that she's there and wants to go by. Well, we don't see that happening in the video. And it's certainly not in the context of people trying to exit a crowded church, ball game where there's a big crowd, getting out of that crowded elevator, getting onto it. We don't have any of that going on. We've got a very evolving, hostile situation in a politically charged event that is going on, which they don't bring up in their closing. But folks, please do not lose the context of when and where all of this took place. This isn't a bunch of friendly people who just attended a concert or a movie. Everybody was there to have a good time. That's not what was happening. But okay, let's give him this alleged tap on the arm, not the grab as was described, not the force that he feels being pressed on his arm in order for her to push her way past. Let's give him that one. Okay, well, how do we know that still it can't be a battery? Because after they've had their jockeying for position, and his arm goes out, and as she's trying to force her way through, she's pressing against it. But let's go with their theory for the moment that his arm is in going back and apparently briefly touches her belly or her abdomen. That's apparently the battery here. And when that's done, he's turned, he's looking at her, his hands are behind his back, he's certainly not touching her, he's trying to avoid contact with her. And she strikes him in the chest. Just taps. Well, at this point, it ought to be obvious to everyone, especially Miss Darden Coons, that this is not somebody who is having a friendly interaction with her. She strikes him. They have her admission to it. If you slow down the videos enough and watch closely enough from the various angles, you'll get to see it, although it's brief. Again, striking can happen in microseconds, it usually does. But again, this isn't a contested, he's saying she did it, she's saying she didn't. He's fully disengaged with her, and she strikes him. But that is not a battery, despite the language here. Miss Hogan comes up and joins the circumstance. And you've got video, which apparently the detective analyzed, of her walking all the way across this auditorium with her hands shoving on Michael Keller. Well, we know that's not battery. That can't be battery, because these gentlemen, who certainly leave their politics and their opinions at the door because we're a nation of laws, and justice is blind, and we don't make charging decisions based on anything but following the evidence, and their years of experience as prosecutor and cop, with evidence they've had for a year and a half, that's not battery either. And when Teresa Bornhall has been removed from the hall, and Michael is attempting to return to his seat, and Nancy Hogan confronts him, gets in his personal space after there's no reason for them to have any continuing contact whatsoever, and Megan Dardis Coons comes up and reaches across and shoves him, which we've got screenshots, which you folks are going to get to take back there, and you can watch the video again and watch her do it. We know that's not battery either. Because if it were, these gentlemen, the agents of our local government, who have no agenda but to apply the law fairly, absolutely, and most certainly would have charged them. They would be the one in the defense seat, effectively, if we're going to go back to Old England, standing on the dock and facing the jury to answer for the charges. They're not. Why not? Well, it's because our government tells us that all of those contacts, despite being unwanted, despite being unsolicited, despite being undesired, and certainly despite being absolutely unneeded or unwarranted, we're okay. Not a crime, not a battery, not an unwillful, unlawful use of force, not an actual, intentional, or unlawful touch. It's none of that. Well, if we accept that logic, then a man who sees a need, who's spent his whole life volunteering for our republic, and then for his church, the community that he attends, sees a need, sees an unfolding event in this hostile situation, and steps up to use what he's been trained and what he has years of experience to do to create some space, because there weren't enough people. He steps up to do that and is approached from behind and contacted from behind and asks you in the split-second moment when he realizes, I'm not just being jostled, I'm being grabbed, and someone is forcefully pushing me, and has to respond and react. And again, this is happening, and the decision tree is taking place in moments, in under a second. And so I think we see him, and even he said, I think I remembered it wrong. Left foot goes out to stabilize, right foot and arm go out to the right to maintain the space. And then he turns to finally see who is the assailant. Is this something where I'm going to need to take greater actions? Do I need to retreat? Do I need to fight back? Again, he has to make these decisions in real time, in the moment, with the limited information that he has. His intention, he has none towards Megan Dardis Coons. It's to maintain the spot that he's at, and once she has initiated this contact, to respond to it within the law, what the law allows, which again, he doesn't have to know that, but we all know. I think intrinsically, though probably we know it as well, you gotta be acting reasonably in the actions that you take. He didn't turn around and punch her. He didn't turn around and shove her. He simply turned, realized who it is that he, I don't know how much, 7, 8, 9 inches taller, heavier, and puts his hands behind his back. So if his reaction to an unknown threat that has developed in the context of a political event, and folks, look, you would have to not just be living under a rock. You would have to be living under a rock that is over a hole that has a box drilled into the bedrock since, say, 2015 forward, to not be aware that when you are at a political event where there are people with very strong opinions on both sides, that injury and damage is not just possible, it is a likely outcome when things erupt. And things at this event had erupted. Again, this isn't a ball game where everybody's having a good time. This isn't a choir recital where everyone's come to watch the kids and they're really happy to have seen it. This isn't an event where somebody went to the local playhouse and got to watch a production. Wow, that was a moving performance. We don't have that going on here. We have a man who stepped up to try and help when he perceived a need. And counsel here is arguing, you don't get to appoint yourself the bouncer or the hall monitor, or I don't remember how many different analogies he's put out there. And you know what? If we were in, I don't know, China, maybe the European Union, he would be right. He absolutely would be right. In those places, they've taken a position that we have this overarching bureaucracy that controls everything. It's sort of like an ant colony. You're born into a particular role, or you develop into it. You can be the worker, or the soldier, or the food gatherer, or whatever the various ants do. God help you if you step outside of your lane, because it demonstrates there's a complete genetic mutation here. Or in those places, well, you need permission to do anything outside your lane. But that leaves out one tiny little problematic detail. We're not subject to the CCP. We're not subject to the European Union or any other government. We're Americans. We don't like being told what to do. And we're not just Americans. We are Idahoans. We really don't like the government getting involved in the things that we do and the choices that we make. They are the ones that have to stay in their lane. And unless our legislature has passed a law specifically prohibiting something, we get to do it. And they don't get a say. He had a right to be there. He had a right when he saw an evolving and developing need in a hostile situation to use the training that he got when he was serving our country. And when he was acting as a retired, now senior citizen, as security for his church, and say, I can at least stand here. I can stand up because I watched our duly elected sheriff direct the removal of people who are shouting down the speakers, who have created a public disturbance. By the way, another criminal act. And there wasn't enough guys. And again, this wasn't, he didn't try and go hands-on. I don't mean any offense, he's an old man now. But he did say, here's what I can do. I can stand here. I can be a physical barrier. I can give them a little bit of room for the few moments it's going to take for them to remove this person who has refused the request and then the order by our sheriff to vacate the premises, and then had to enforce the physical removal. And frankly, whether you like or disagree with the sheriff's decision is beside the point. It was something that happened. And this is a citizen who observed that and stepped up. So ultimately, what's a battery? Well, look, I'll give you some common sense examples. 2nd grade, 3rd grade, playground bullying. Asserting himself. He's the tough guy. He and his pack of toadies come up to the new kid. And he gets poked in the chest, flicked in the ear. That's a battery. That's a battery. What about the bar? Friday night, everyone goes out, they're having a good time, people getting their drink on. One guy's finished his, he's on his way up to the bar to get another one. Another guy has just refilled his drink at the bar, but it's crowded. And so as the first guy is passing the second guy, there is just a jostling of elbows. Unfortunately, the new fresh drink is spilled. So that guy, little alcohol on board, feeling no pain, just slugs the other guy for spilling the drink. Battery, absolutely. What about household? Couple, they get into an argument. We're back in the master bedroom. One of them says, I've had it, I'm done, I'm not listening to this anymore, I'm headed to wherever. Mom's, my sisters, the club, work, I'm out of here. This conversation's done. And the other person says, oh, no, it's not. And she or he stand right in the doorway and blocks access. When the other person attempts to move past, shoves them back. Well, that'd be a domestic battery, but the only difference between simple domestic is the fact that they have that relationship. Battery, yep. Those are all examples of battery. Well, what if a parent happens to be bringing their kids homework because they left it, mine used to be notorious for that, and sees the playground bully pushing, not even that parent's child, another one, get flicked in the ear. The kid's certainly upset about it, and intervenes. Not a parent, not a school resource officer, not school security, not even the parent of that child, but just gets in the middle. According to the state, can't do it. Can't do it. And what if the bar, where the fight breaks out, the bouncers are tied up out back, out front, they don't see it. Apparently, if you're there and you're seeing these guys starting to swing, if you step up and prevent that, you're subjecting yourself to being prosecuted because you can't appoint yourself security or the bouncer. You don't get to step up and attempt to intervene to prevent these things. if you are, say, the overnight house guest, maybe the people put out, I think there's couchsurfing.com. So let's just pretend you just happen to be, that's the house, you accepted a couch, and they get into this thing, and you just watch this. You can't intervene in that domestic. Again, well, you're not part of the family, you're not law enforcement, you gotta leave it to the experts, the professionals, you just can't get involved. That is flat wrong. You absolutely can do any of those things to prevent that. Now, first off, this isn't battery, because again, by their own logic, it can't possibly be a battery, which means their evidence fails. They haven't proved it beyond a reasonable doubt, and that should be the end of it. But you don't have to take my position. Maybe you don't find what I'm arguing, the position I'm asserting on behalf of Mr. Keller, persuasive at all. Well, okay, if you find that in that moment, as he's standing there, that when he feels that contact and that pressure on his arm, that when he extends it, not knowing, and she's forcing her way through, that actually was an unlawful touching, because I can't come to the conclusion that it's anything else. If it's anything, that's as good as it gets. Let's say we're there. Did he have a right at that time to act in self-defense? If that's the case, if it would, under other circumstances, constitute a battery, then we gotta look and see. Well, first off, he has to be acting reasonably, and the amount of force that he uses has to be reasonable under the circumstances. Okay? So he has to have a reasonable fear of bodily harm. So he's standing in a staged auditorium, so he's on a slope. This is a man who's a senior citizen. He feels, in the context of this incredibly hostile crowd, a hand on him that he perceives is not normal jostling. He told you that. Told you that. He perceives this as a threat, and he's reacting to it. Now, if the pressure increases and he's shoved on this slope, he might fall. When you go down, well, I'm in my mid-50s. I certainly don't bounce the way I did when I was, say, 17. I'm not sure what a man 15 years my senior might be thinking, but I'm sure it's more, it's a greater level of concern that even a guy in his mid-50s might feel. Is the person going to follow that shove, punch, kick, with a bottle, with some kind of knife, or shiv, or razor blade? Because again, we've seen the last 10 years what happens at the mostly peaceful protests. Is it reasonable for a person in that moment to have concern for bodily injury? Again, I don't know how anyone can conclude otherwise, given those facts. Again, this isn't something where he has time to contemplate. He doesn't even know who his assailant is. Male, female, big, small. Again, in that moment, he's reacting to what she initiated. So, is then his response to it, to this, as his brain is processing this incoming threat, this contact initiated by the other person as a threat, is that response, one, to maintain the perimeter as he's been trained both by the United States Navy and then by the church security, to maintain that and then to try and stay upright and to respond? Is that reasonable? Again, by extending his arm as she's attempting to force her way through that space. This isn't purely one-sided here. She didn't have to do that. chose to. Was it reasonable? And then when he's turned and he sees who the assailant is, he made a second, in the decision tree, he made a second decision. I don't need to take any other action other than to continue to stand here, as he put it, to stand my ground. His hands go behind his back. And they remain there, literally all the way across the auditorium. He had a right to walk across there. He had a right to step up and offer help. And frankly, it blows my mind that we're told this had nothing to do with the fact that it's a political event. Had this been a car wreck, and he'd stepped up to create a perimeter for the paramedics to work, and say a very distraught family member of the person who's been in maybe a horrible wreck runs in because they're so emotionally overwhelmed they want to hug or put their arms around the injured person, and he literally almost bear hugged them or tackled them to keep them back, not because he wants to injure them, but because if you don't let those EMTs and paramedics do their job, somebody might die. We wouldn't be here. Frankly, if he'd stepped up in the rowdy bar and just tried to pull the guys apart that are slugging it out, we wouldn't be here. If he'd been the parent at the schoolyard, we wouldn't be here. None of that, despite what the argument was. We're here because this was a political event. And Coeur d'Alene took sides. Because if they didn't, all three would be here. But he's the only one that is. And they can't have it both ways. If what those women did isn't battery, which was far more egregious than this man did, then by their own logic, neither is his action. But finally, folks, again, if you're persuaded it was, everything he did in that second where he is reacting was a reasonable amount of force and reasonable under the circumstances, and therefore it was self-defense. And again, there's other instructions there. Please look at all of them. I mean, this isn't the council talked about the mutual combat. This isn't like these two guys agreed to go out, or people, let's go out in the alley behind the high school and throw down. There's no prearrangement. They're not fighting by mutual agreement. And then one of them's like trying to tap out, the other one's like, this is my opportunity. We don't have that going on at all. So what we're left with is a citizen who spent his whole life stepped up one more time. Because he picked or was associated with the wrong side, he's here. He didn't commit a crime. He definitely did not commit a battery on that woman. And if you find somehow that he did, he certainly was acting well within his rights of self-defense. Please tell our government not to do this again, because this man is not guilty of any criminal offense. Thank you.
And Madam Clerk, if you will now read the verdict.
In the District Court of the First Judicial District of the State of Idaho, in and for the County of Coeur, verdict form, State of Idaho versus Michael Keller, CR 28-25-6162. We, the jury, unanimously find the defendant, Michael Keller, not guilty of battery. Dated the 17th day of July 2026, signed Jackson Coeur.
Members of the jury, so say you all, this be your verdict. The record reflect our unanimous noddings and a couple yeses being said. Everyone may be seated. I will enter the judgment of acquittal, and Mr. Keller, you are free to go. Parties may be excused, and we are adjourned.
Yeah. Thank you. No, sorry, I didn't figure it out. Yeah, fine. All good things. Thank you.